Apologies for the delay on posting this assignment today. I realized this morning when I woke up that there was a problem with the upload and I needed to re-record the second part of the lecture. So it took me a little while to do that, but wanting to finish off where I left off on the first part, which is that the Fourth Amendment, which we said is, again, one of the many Bill of Rights amendments guaranteeing the civil liberties that protect people from um, when they're accused of a crime. And the Fourth Amendment specifically is unreasonable search and seizure, which has been held by the court to be lots of things. Interestingly enough, the Fourth Amendment, coupled with a couple other different amendments, was read by the court to provide for the fundamental right of privacy. And we'll talk more about that later. But the court, there was basically a court case that said, is there a constitutional right to privacy? The word privacy is not in the Constitution anywhere. And so the court basically heard the arguments and found that the justices found that when you read the Fourth Amendment, which is protection from unreasonable search by the government, and you read it in conjunction with a couple other Bill of Rights amendments, that there is an implied right to privacy, that if you cannot be unreasonably searched, um, and maybe I'll get the other ones later, then there is the fundamental right to privacy. And this constitutional right to privacy ended up being the precedent established there ended up being the basis on which Roe v. Wade was decided. That the court didn't necessarily think abortions were a great thing. Nobody does. But that there was actually no business of the federal government intruding in women's health care because that was a private issue and therefore not the domain of the federal government to prevent. But going back specifically to the Fourth Amendment with warrants, with unreasonable search and seizure, that we talked about probable cause and that how, for a planned search, if at all possible, police have to secure a warrant from a judge where you will present why you think this person is guilty, what evidence you have, who issue a warrant. But searches can also be warrantless, right? We've seen that in cop shows. And the court has basically established that the conditions that need to be present for a search to be warrantless is that A, you need to have probable cause in the moment and you need to be able to justify it afterwards. Um, or the officer's safety is threatened. So, if you're driving down the street and, well, let me think of a better scenario here. If basically you have to arrest somebody or search somebody for something because the officer's safety um, is threatened, for example, like maybe you're worried that they have syringes in their pockets or something that could otherwise hurt you as you are basically taking them in for a speeding violation. That the officer's safety is threatened, therefore you can search their person, or you believe that there is imminent destruction of evidence if you do not begin to there. So if you get to a crime scene and you think like, oh, I see um, basically footprints up to this house, and I know that if I don't go in right away, there's a good chance that the murder weapon or whatever will be disposed of. That the officer could follow the footprints, walk straight in, claim that the probable cause, suspected imminent destruction of evidence, and so even if they didn't get a warrant before that, that evidence secured in that search would stand. And then lastly, the search for a warrantless search needs to be limited to an item involved in the crime you're specifically looking to, or something in their direct possession. You can't just have a warrantless search for somebody's job. You would still have to get a warrant for that. You can enter homes without a warrant if police officers believe that somebody inside is seriously injured. This is the basis for a lot of accusations of corruption because cops will sometimes say, well, like I heard screaming or I heard sounds of a struggle inside. And, there may not have been screaming, there may not have been struggle, but if those are present, obviously the police officer can enter a home without a warrant if they believe that they are protecting someone. But this also again is very difficult to prove that didn't happen. And so what happens if an officer secures critical evidence, but secures it in a way that doesn't kind of pass these court mandated standards, right? That they find it in a warrantless search, and they prove that none of the conditions were present, or maybe they have a warrant looking for something, and then in the search find something else. Um, Basically, the courts have ruled that any evidence that is obtained outside of these boundaries is subject to the exclusionary rule, and therefore would be like excluded from trial. The case that established this and incorporated this decision to the states was Mapp v. Ohio. And I believe this is a must know case. I will clarify this, but essentially, what the Mapp case did was um, there was a chase for a fugitive back in the 1970s or 60s, where the police were chasing after a fugitive for a wanted crime, and the fugitive went through somebody's house. And so basically, the police follow them, run through the front door, following, and as they're running through this person's house, they noticed a significant amount of child pornography, um, basically in plain sight in the house that they were running through to catch this other fugitive who didn't live there. And so they caught the fugitive, but then they arrested the person whose house they ran through, trying to get the other person. And basically, the court said, while clearly, and this was a woman, well, clearly, ma'am, you are doing something like horrible and illegal, and, we're going to get you other ways. All the evidence that the police found on that day is inadmissible in court, and therefore your arrest and trial is tossed out. Because otherwise the police could basically say, well, we were chasing somebody all the time, and we just happened to walk in a house, and we saw you, a bag of drugs sitting on the table, and it's like, well, you can't use the bag of drugs that you find in a warrantless or illegal search as evidence as for crime, and so that would toss it out. That was Mapp v. Ohio. We'll talk more about that when we get to the must know cases at the end of this week. Um, Now, the Patriot Act has, famously passed in the years after 9/11, um, was an act of Congress that changed some of the standards legally, that greatly decreased all of these Fourth Amendment protections when applied towards terrorists. That terrorists were considered enemy combatants, right, or enemies of the state, enemies in a war on terror, and therefore were not afforded the same constitutional civil liberty protections of citizens. And so the Patriot Act basically greatly decreased. There's been a lot of challenges to that Patriot Act by the ACLU, because sometimes the Patriot Act is being applied to regular citizens too who are not involved in terrorism. But generally speaking, the court has upheld that when targeting enemy combatants or enemies of the state in a war on terror, that um, that basically the Fourth Amendment protections are not the same. So moving on, what rights do defendants have according to the Bill of Rights? We talked about the Fourth Amendment. Let's talk about the Fifth Amendment. You've heard this before in television shows when people say, "Well, I plead the Fifth." Where somebody gets on the witness stand and they ask a question, you go, "I plead the Fifth." And the Fifth Amendment, quite simply, it basically protects people from self-incrimination. And so, if you put somebody on the witness stand and you swear them in, and the penalty for lying on the witness stand is jail for perjury, then basically there's nothing stopping the government without the Fifth Amendment from putting you on the witness stand, threatening jail with perjury, and saying, okay, so did you do it? And um, if the person said no and they could prove it, then the person would go to jail not just for committing the crime, but also for perjury and go to jail for longer. And so, the Fifth Amendment basically was passed that said you have a constitutional protection not to self incriminate. You don't have to present evidence against yourself or your spouse. It extends to spouse or immediate family member. You don't have to present evidence that would incriminate or make guilty yourself. And so you can plead the Fifth and therefore not answer the question or not supply the response to what you're being asked of. And this basically puts the burden of proving guilt on the government, right? It is the police. It is the government's responsibility to prove you are guilty. It is not your responsibility to basically admit it. That has been obviously upheld. It's what the Fifth Amendment directly states, and we'll look at challenges here um, going forward.
Sorry about that. Continuing, sorry, I had to pause and take a quick call from Ms. Stokes. We said the Fifth Amendment obviously is the famous "I plead the Fifth." It's a protection against self-incrimination that places the burden of proof, as we said, on the police or the prosecutors, not the accused, to basically prove their guilt. Um, I don't need to talk too much about it. I think you've probably heard enough. But the flip side of this is because prosecutors and um, federal lawyers know that anytime you basically want to get a person to provide information that may be used against them, they can just take the fifth. Often the workaround here is immunity, right? And you've again, I'm tapping directly into your CSI slash Law and Order slash movie watching tendencies. Prosecutors will often, federal prosecutors, the Attorney General will say, well, I will offer you immunity if you will give yourself up and that of the person who put you up to it, or provide other information. Um, Now, what has developed over the last 50 years specific to the Fifth Amendment is what you see in the bottom left hand corner of this screen, right? We know that the Fifth Amendment provides all citizens of the United States protection against self incrimination. But in the famous case Miranda v. Arizona, which was in the I want to say 60s, um, there was a case that basically brought front and center that the majority of Americans were not all that informed of their constitutional civil liberties. Goes back to kind of that idea of why do we have government classes in the first place, so that kids know their rights, they know how the system works, and that they're more educated on kind of the system that they live in. But the reality was, in Miranda v. Arizona, there was basically this man here. I'll hover my camera here over him, right here, number two. And this, he was a non-native English speaker, but a citizen of the United States who was arrested in Arizona, and basically. Because he didn't know about his Fifth Amendment rights, he confessed and basically said a lot of stuff. And it wasn't for anything serious. I believe the case was involving, well, I mean, this is pretty serious, but it wasn't like murder or rape or anything. It was assault. And so he basically said all this stuff and he went to jail for a fairly long time in response to this assault conviction that he provided all the evidence against himself. And so basically, on appeal, it was argued that Miranda, the man, did not know his constitutional civil liberties and therefore was basically being abused by arresting officers who took advantage of that. And so Miranda v. Arizona established that you must inform any person you are arresting of their Fifth Amendment rights, right? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney and have them present with you while you're being questioned. If you cannot afford an attorney, one will be appointed. You've heard it before. And if it is proven that your Miranda rights were never read to you and you were not informed of your rights and you offered evidence against yourself, then a mistrial will be declared. The only exception to a mistrial being declared and letting somebody go is if there is enough evidence to secure a conviction without any of the defendant's testimony, then the judge has the choice of whether or not to declare a mistrial, not forcibly. Um, all that being said, once you are read your Miranda rights, the defendant or the person being arrested has to very clearly invoke these rights. They have to either say, I would like an attorney, or basically stop talking. If they are informed of their rights and then they continue to dribble out evidence against themselves, they cannot invoke their Fifth Amendment right later or argue that they were somehow denied it. Now, as you might expect, the Supreme